In the previous section, we examined the essential and optional elements within listing and buyer employment agreements, focusing on what makes them valid and enforceable. Those agreements not only establish the broker's authority, but also determine the conditions under which compensation is earned. In this section, we build upon that foundation by exploring the various types of real estate transactions in Arizona and the specific circumstances under which a broker is entitled to payment. Understanding these distinctions is critical for every licensed professional because compensation rights are governed not only by contract law, but also by Arizona statutes, such as ARS, Paragraph 32, 2151.02, and Paragraph 32, 2155, and by long-standing case law that defines when a commission is considered earned. Types of real estate transactions listing. Seller representation transactions. In a traditional listing agreement, the broker represents the seller and is compensated when they produce a ready, willing, and able buyer according to the seller's terms. This means the broker earns their commission once the buyer accepts the offer, even if the transaction fails to close, provided that the buyer's failure was not the broker's fault. For instance, in Ellsworth Dobbs, Inc. versus Johnson, 1967, courts recognized that a broker earns compensation when they fulfill their contractual obligations by procuring a qualified buyer under the agreed conditions. In Arizona, however, most listing agreements tie commission payment to the successful closing of escrow. The agreement must clearly define when and how the broker's commission is due. For example, commission shall be paid at the close of escrow from seller's proceeds, or buyer is seller does not agree to compensate the buyer's agent. Ensures payment is contingent upon completion of the sale. Ellsworth Dobbs, Inc. vs. Johnson, 50 NJ 528, 236 A2D 843, 1967, is a landmark real estate brokerage case in which the New Jersey Supreme Court fundamentally changed when a broker earns a commission. The court held that, absent an agreement to the contrary, a real estate broker is not entitled to a commission merely for producing a ready, willing, and able buyer if the transaction fails to close due to the buyer's inability to perform. Instead, the broker's right to a commission is conditioned on the successful closing of title, unless the seller's wrongful conduct prevents closing. The decision shifted the risk of buyer default from the seller to the broker and emphasized fairness, recognizing that sellers reasonably expect to pay commissions from sale proceeds. Although not an Arizona case, Ellsworth Dobbs is widely cited and influential in brokerage law discussions nationwide. Buyer representation transactions. A buyer-broker agreement authorizes the broker to represent the buyer's interests in locating and negotiating the purchase of property. Compensation may be paid by the seller, the listing broker, or directly by the buyer, depending on what is stated in the written agreements. Under ARS, Paragraph 32, 2155A, the broker must still receive payment only through the employing broker, never directly from the client. Remember that the seller is not obligated to offer any compensation to the buyer's broker anymore. An example would be a buyer who signs an exclusive buyer-broker agreement with broker A. The buyer later purchases a home found through another agent without notifying broker A. If the buyer agreement specifies that the broker is entitled to compensation regardless of who procures the property, broker A may still be owed a commission for breach of contract by the buyer. Leasing transactions. Brokers in Arizona often handle leasing transactions for landlords or tenants. The employment agreement must specify the commission structure, often a percentage of the total lease amount or 1 month's rent. Payment is generally earned when a tenant signs a binding lease, although some agreements defer payment until the tenant takes possession or the first rent payment is made. For example, a broker represents a landlord in leasing a commercial suite
in Scottsdale. The tenant signs a 5-year lease, and the landlord agrees to pay a percentage of the lease as commission on the first year's rent. If the tenant defaults after 3 months, the broker still earns the agreed commission because the lease was executed under the broker's agency. Make sure that all agreements are clear and specifically stated. Referral and cooperative transactions.
Brokers frequently engage in referral arrangements or cooperate with other licensed brokers. In these cases, compensation must be agreed to in writing before the referral or cooperation takes place. Under Commissioner's Rule R428-1D, brokers must deal honestly and disclose all material terms of compensation to their clients. For example, a broker in Arizona refers a client relocating to Colorado to a Denver broker. A referral fee of 25% of the commission is agreed upon in writing. Once the Denver broker closes the sale, the Arizona broker lawfully collects the referral fee from the Denver broker to the referring agent's brokerage. When is compensation earned? Under Arizona law, a broker earns a commission only when the terms of the written employment agreement are satisfied. ARS Paragraph 32 to 2151.02 requires a written contract between the broker and client, while Paragraph 32 to 1555 reinforces that compensation can only be received through the employing broker. A broker's right to commission typically depends on one of the following conditions being met. The broker produces a ready, willing, and able buyer or tenant who agrees to the terms set forth by the client. The transaction closes successfully as stated in the employment agreement. The client breaches or cancels the agreement after the broker has already performed under its terms. Courts have upheld that a broker is entitled to commission even if the client refuses to close without legal justification. For example, in Mann v. Glaze, Ares Apiari, 1984, the court affirmed that a broker's right to payment arises once they fulfill their contractual obligations, regardless of whether the principal later withdraws from the deal. Commission disputes and enforcement. If a broker or salesperson believes they have earned a commission but have not been paid, they may pursue civil remedies. However, the claim must be based on a valid written employment agreement. Without such documentation, the Arizona courts will not enforce payment as established in James v. Hiller, 1958. Additionally, ARS Paragraph 33-1071 allows brokers to record a lien on commercial property to secure unpaid commissions, provided that the lien and notice requirements are strictly followed. This process is governed by the Commercial Real Estate Broker Lien Law and serves as a legal safeguard for brokers who have earned commissions but have yet to be compensated. Review summary. Every real estate transaction, whether for a sale, purchase, lease, or referral, must be grounded in a written employment agreement. Compensation is earned only when the broker performs according to the terms of that agreement and is payable exclusively through the employing broker. The precise timing and conditions for payment depend on how the contract defines earned commission. Understanding these distinctions ensures compliance with Arizona law, prevents commission disputes, and strengthens the broker's legal position. Discussion prompts and answers. What determines when a broker earns their commission in a real estate transaction? Answer. The broker earns their commission when they fulfill the terms of the written employment agreement, such as producing a ready, willing, and able buyer or successfully closing a transaction. Why is it essential for compensation agreements to be in writing? Answer. Because the Statute of Frauds and ARS, Paragraph 32-2151.02, require written agreements for real estate compensation to be enforceable, protecting both broker and client. Can a broker be compensated if the client refuses to close without cause? Answer. Yes. If the broker has fulfilled their contractual duties, the client's refusal to close without legal justification does not eliminate the broker's right to compensation.